If you're a landlord or property manager anywhere in the United States, understanding the rent increase laws in your state is critical because getting it wrong can result in invalid increases, tenant complaints, retaliation claims, fair housing violations, and in some states, significant financial penalties. The rules governing how much you can raise rent, how much notice you must provide, and what restrictions apply vary enormously from state to state. That's exactly what this series covers. At TenantScreeningBackgroundCheck.com, we've created individual videos and comprehensive written guides for all 50 states, Washington, D.C., and Puerto Rico, breaking down the rent increase regulations that apply in each jurisdiction. Whether you own a single rental property or manage a large portfolio, knowing the specific rules in your state isn't just good practice. It's a legal requirement. So let's talk about the big picture. The first question every landlord asks is, can I raise rent as much as I want? And the answer depends entirely on where your property is located. The vast majority of states have no cap on rent increases. In these states, you can raise rent by any amount the market will bear, 5%, 10%, 20%, or more, as long as you provide proper notice and the increase isn't retaliatory or discriminatory. Most states in the South, Midwest, and Mountain West fall into this category, and many of them have enacted preemption statutes that specifically prohibit cities and counties from imposing local rent control. But a handful of states and dozens of individual cities have enacted rent control or rent stabilization laws that cap the amount landlords can charge. Oregon has a statewide rent cap, currently 7% plus the Consumer Price Index, with a maximum of 10% in any 12-month period. California has a statewide cap under AB 1482, 5% plus CPI, or 10%, whichever is lower, plus dozens of local ordinances in cities like Los Angeles, San Francisco, Oakland, San Jose, and Berkeley that impose even stricter limits. New York has its famous rent stabilization system covering roughly 1 million apartments in New York City. New Jersey has over 100 local rent control ordinances, and cities like St. Paul in Minnesota have enacted flat percentage caps, 3% annually in St. Paul's case. The trend line matters too. Several states that have traditionally had no rent regulation are seeing active legislative debates. Colorado recently repealed its preemption statute, meaning local rent control is now legally possible there. Illinois' preemption status has been contested. Vermont has seen Burlington enact CPI-based rent stabilization. Washington state now requires 180 days' notice for rent increases, the longest in the country. Even though it doesn't cap the amount, the regulatory landscape is shifting, and landlords need to stay current on developments in their specific state and city. Now let's talk about notice requirements, because even in states with no rent cap, you still must provide proper advance notice before an increase takes effect, and the required notice periods range from remarkably short to remarkably long. At the short end, Louisiana requires just 10 days' notice for a rent increase, the shortest in the country. North Carolina requires just 7 days for month-to-month tenancies, though most leases specify 30. Florida requires 15 days. Utah requires 15 days. These short-notice states give landlords maximum flexibility to respond to market conditions quickly. At the long end, Washington state requires 180 days, a full 6 months, before a rent increase takes effect. Oregon requires 90 days. Delaware and Vermont require 60 days. Hawaii requires 45 days. These longer notice periods give tenants substantially more time to plan, budget, or find alternative housing if they can't absorb the increase. Most states fall in the middle with a 30-day notice requirement for month-to-month tenancies. This is the most common standard across the country and is what most landlords and tenants expect. For fixed-term leases, the rules are different and more consistent across states. During a fixed-term lease, the rent is locked in unless the lease includes a provision allowing mid-term increases, such as an escalation clause, a CPI adjustment provision, or a clause tied to property tax changes. Without such a provision, the landlord must wait until the lease expires to propose a new rent amount. One thing that's consistent across every single state: rent increases cannot be retaliatory. Every state either has a specific anti-retaliation statute or recognizes the common law principle that landlords cannot raise rent as punishment for a tenant exercising their legal rights. Protected activities typically include making a repair request, filing a habitability complaint with a government agency, reporting code violations, participating in a tenant's organization, and exercising any right provided by the state's Landlord-Tenant Act. The strength of these protections varies dramatically. Some states create a rebuttable presumption of retaliation if the landlord raises rent within a specific window after the tenant's protected activity. The presumption periods range from as short as 90 days to as long as 1 year. Nebraska and Iowa have 12-month presumption periods, among the longest in the country. North Carolina also provides 12 months. Massachusetts, Connecticut, Vermont, Washington, Oregon, Kansas, Virginia, and Alaska all provide 6-month windows. In states with these statutory presumptions, any rent increase delivered within the window after a tenant's complaint automatically triggers the presumption, and the landlord must prove the increase was motivated by legitimate business reasons to overcome it. Other states, particularly those without comprehensive landlord-tenant acts, rely on common law anti-retaliation principles without a statutory presumption period. In these states, the tenant can still raise retaliation as a defense, but bears a heavier burden of proving the landlord's retaliatory intent. Rent increases also cannot be discriminatory under any circumstances, in any state. The Federal Fair Housing Act prohibits rent increases based on race, color, religion, national origin, sex, disability, or familial status. Many states add additional protected categories: sexual orientation and gender identity, source of income, marital status, age, ancestry, immigration status, and others. A rent increase that targets tenants based on any protected characteristic exposes the landlord to federal and state fair housing liability. Source of income protection is a growing area of law that directly affects rent increase practices. A significant and growing number of states and cities prohibit landlords from discriminating against tenants who pay with housing choice vouchers, Social Security, disability payments, or other lawful income sources. In these jurisdictions, a rent increase designed to push out voucher holders while keeping rates stable for other tenants could constitute source of income discrimination. Some of the most important state-by-state differences we cover in this series include whether the state has a preemption statute preventing local rent control. States with preemption, including Texas, Tennessee, Georgia, Florida, Indiana, Iowa, Kansas, North Carolina, Idaho, Utah, and Wyoming, among others, have ensured that no city or county can impose rent caps, creating a uniform market-based framework statewide. States without preemption, including California, New York, New Jersey, Massachusetts, Maryland, Connecticut, and others, leave the door open for local regulation, and many cities have walked through that door. We cover the specific notice periods for each type of tenancy: monthly, weekly, and annual, in every state. We cover whether the state has any special provisions for manufactured home communities, which often have their own rent increase rules. We cover how military BAH rates interact with rental pricing near major installations. We cover how the Housing Choice Voucher Program affects rent increase procedures for participating landlords. And we cover the security deposit implications of rent increases, because in some states, raising rent changes the maximum allowable deposit, while in others, it doesn't automatically entitle the landlord to collect additional deposit from an existing tenant. For landlords, the practical takeaway across all 50 states is the same: document the business justification for every rent increase, apply increases consistently across comparable units, provide proper written notice using the correct timeline for your state, and never raise rent in response to a tenant exercising their legal rights. The landlords who get into trouble are the ones who implement inconsistent increases, fail to provide proper notice, or raise rent immediately after a tenant files a complaint. For tenants, the practical takeaway is equally clear: know your state's notice requirements and your rights. If you receive a rent increase that doesn't comply with the required notice period, the increase may be invalid. If you believe the increase is retaliatory, meaning it was triggered by a complaint you made or a right you exercised, you may have grounds to challenge it. And if you believe the increase is discriminatory, you can file a complaint with your state's Fair Housing Agency or the Federal Department of Housing and Urban Development. Every state guide in this series covers the specific statutes, notice periods, caps if any, anti-retaliation provisions, and practical market analysis for that jurisdiction. We've included information about local rent control ordinances where they exist, military housing considerations, and housing choice voucher procedures. To find your state's complete rent increase guide, visit tenantscreeningbackgroundcheck.com and look for our rent increase laws by state page. We have all 50 states, Washington, D.C., and Puerto Rico covered with detailed written guides and video walkthroughs. Subscribe to our channel to get every state in our rent increase law series, plus our habitability laws, lease termination laws, and tenant screening compliance series. And if you need a fast, affordable tenant screening or background check, visit tenantscreeningbackgroundcheck.com. No account needed, results delivered quickly, and fully FCRA compliant.